भारतीय नागरिक सुरक्षा संहिता 2023। भारतीय नागरिक सुरक्षा संहिता 2023। Section 155 Information as to non-cognizable cases and investigation. What is Section 155 about? Section 155 explains what the police must do when information is given about a non-cognizable offence, that is, an offence where the police cannot arrest without a warrant and cannot investigate without court permission. Main provisions of Section 155. एक recording of information. When information about a non-cognizable offence is given, the police must record it in the prescribed register. Though reference to magistrate, the police must direct the informant to approach the magistrate having jurisdiction. 3. No investigation without permission. The police cannot investigate a non-cognizable case without an order of a magistrate. 4. Powers after permission. Once the magistrate gives permission, the police may investigate the case, but cannot arrest without a warrant unless the law specifically allows it. 5. Mixed offences. If a case includes at least one cognizable offence along with non-cognizable offences, the entire case will be treated as cognizable. Simple meaning: for less serious offences, the police do not act on their own authority. First, they record the complaint. Then, the complainant must seek court permission. Only after the magistrate allows it can the police investigate. This protects people from unnecessary police interference in minor matters. Example: someone files a complaint of defamation, a non-cognizable offence. The police record the complaint. Tell the person to approach the magistrate. Investigation starts only after the magistrate's order. Purpose of Section 155. Maintains balance between police power and individual liberty. Ensures court supervision in minor offences. Prevents misuse of police authority. भारतीय नागरिक सुरक्षा संहिता 2023। Section 156 Police officers' power to investigate cognizable cases. What is Section 156 about? Section 156 gives the police the authority to investigate cognizable offences without seeking prior permission from a magistrate. It also explains the supervisory power of the magistrate over such investigations. Main provisions of Section 156. एक investigation without court order. A police officer may investigate any cognizable offence without the order of a magistrate. This is the basic legal power behind police investigations after an FIR. To keycap no challenge to police authority. No proceeding of a police officer shall be questioned on the ground that he was not empowered to investigate. This protects investigations from technical objections. 3. Key cap magistrate's power to order investigation. A magistrate having jurisdiction may order the police to investigate a cognizable offence. This is commonly known as an order under Section 156(3). Simple meaning: for serious offences, police can act immediately after receiving information. They do not need court permission to start investigation. At the same time, if police fail to act, a person can approach the magistrate, who can direct the police to investigate. Example: a person reports a cognizable offense like cheating or assault. Police do not register an FIR. The person approaches the magistrate. Under Section 156, the magistrate orders the police to register the case and start investigation. Purpose of Section 156: ensures quick police action in serious crimes, prevents delay in investigation, provides judicial oversight when police remain inactive. Bharatiya Nagarik Suraksha Sanhita 2023. Section 157 Procedure for Investigation. What is Section 157 about? Section 157 explains what the police must do after receiving information about a cognizable offense and deciding to investigate it. It sets out the initial steps of investigation and the role of supervision by senior officers and the magistrate. Main provisions of Section 157. एक sending report to magistrate. When a police officer receives information about a cognizable offense and decides to investigate, he must send a report, FIR details, to the magistrate having jurisdiction. Though starting investigation, the police officer shall proceed to the spot or depute a subordinate officer to investigate the facts and circumstances, discover and arrest the offender if necessary. 3. Key cap when investigation may not be started. The police officer may decide not to investigate if the case is not of a serious nature or there is no sufficient ground for investigation. 4. Reasoned decision. If the officer does not investigate, he must record reasons and inform the magistrate about such decision. Simple meaning: once an FIR is registered for a cognizable offense, police must inform the magistrate. They must begin investigation promptly. If they choose not to investigate, they must give written reasons and Keep the magistrate informed. This ensures transparency and accountability in police action. Example: police receive an FIR for a cognizable offence. They send the report to the magistrate. An officer visits the crime scene and starts investigation. If the complaint is clearly false or trivial, the officer records reasons and informs the magistrate. Purpose of Section 157: ensures immediate investigation of serious crimes. Keeps the magistrate informed and in control. Prevents arbitrary refusal to investigate. Bharatiya Nagarik Suraksha Sanhita 2023. Section 158 Report House submitted. What is Section 158 about? Section 158 explains how the police report, sent under Section 157, must be forwarded to the magistrate. It focuses on the chain of communication and supervision within the police system. Main provisions of Section 158. एक forwarding through superior officer. The report prepared by the police officer in charge of a police station shall be submitted through a superior police officer as prescribed by the state government. The role of superior officer. The superior officer reviews the report and forwards it to the magistrate. 3. Administrative supervision. This system ensures senior officers are aware of investigations and there is oversight and accountability in police functioning. Simple meaning: police reports are not sent casually to the court before reaching the magistrate. The report passes through senior police authorities. This helps prevent errors, misuse of power, or improper investigations. Example: Ensure prepares an investigation report under Section 157. The report is sent to a deputy superintendent or other superior officer. The superior officer forwards it to the magistrate. Purpose of Section 158. Ensures discipline and supervision in investigations. Keeps senior police officers informed. Improves quality and responsibility in police reporting. Bharatiya Nagarik Suraksha Sanhita 2023. Section 159 Power to hold investigation or preliminary inquiry. What is Section 159 about? Section 159 empowers the magistrate to decide the next step after receiving a police report under Sections 157 or 158. It gives the magistrate control to ensure a fair and proper investigation. Main provisions of Section 159. After receiving the police report, the magistrate may order investigation, direct the police to conduct or continue investigation, or though order preliminary inquiry. Conduct a preliminary inquiry himself, or direct a subordinate magistrate to conduct such inquiry. Simple meaning: the magistrate is not bound to accept the police report blindly. Depending on the situation, the magistrate can ask the police to investigate further, or personally examine the matter at an initial level. This ensures judicial supervision over police action. Example: police submit a report saying no offense is made out. The magistrate feels the matter needs closer examination. Under Section 159, the magistrate may order further police investigation, or conduct a preliminary inquiry through a subordinate magistrate. Purpose of Section 159: prevents unfair or incomplete investigations, strengthens judicial oversight, protects the rights of victims and accused. Bharatiya Nagarik Suraksha Sanhita 2023. Section 160: Police officers' power to require attendance of witnesses. What is Section 160 about? Section 160 empowers the police to require the attendance of persons who are acquainted with the facts of a case during investigation. It also provides important safeguards, especially for women, children, and vulnerable persons. Main provisions of Section 160: एक power to call witnesses. A police officer investigating a case may, by written order, require the attendance of any person who appears to be acquainted with the facts and circumstances of the case. Though jurisdiction limit, such person must reside within the limits of the police station or within such distance as prescribed. 3. Key cap protection to women and vulnerable persons. Women, children, and persons above a prescribed age or with disability shall not be required to attend the police station. Their statement should be recorded at their residence or place of choice. 4. Reasonable expenses. The police must pay reasonable expenses for attendance, except for residents of the same locality. Simple meaning: during investigation, police can call witnesses for questioning, but they cannot harass or inconvenience people unnecessarily. Special protection is given to women and vulnerable persons. Example: police are investigating a theft. A neighbor who saw the incident may be called for questioning. If the witness is a woman, police must record her statement at her home, not at the police station. Purpose of Section 160 helps police collect facts efficiently, prevents misuse of power, protects dignity and convenience of witnesses. Bharatiya Nagarik Suraksha Sanhita 2023 Section 161 Examination of witnesses by police. What is Section 161 about? Section 161 explains how the police may question persons, witnesses, during an investigation and what legal safeguards apply to those statements. Main provisions of Section 161. एक power to examine witnesses. A police officer investigating a case may examine any person who appears to be acquainted with the facts and circumstances of the case. Though duty to answer truthfully. Such person is bound to answer truthfully all questions relating to the case. Teen protection against self-incrimination. A person cannot be compelled to answer any question. If the answer would expose him to a criminal charge, penalty, or forfeiture. This protects the constitutional right against self-incrimination. 4 mode of recording statements. Statements may be recorded in writing or recorded by electronic means as prescribed. The witness does not sign the statement recorded by police. Simple meaning. During investigation, police can question witnesses and record what they say. Witnesses must cooperate and speak truthfully. But no one can be forced to incriminate himself. Police statements are not signed to avoid pressure or misuse. Example: police investigate an assault case. They question neighbors who saw the incident. A witness must answer honestly. If a question may make the witness guilty of an offense, he may refuse to answer that question. Purpose of Section 161 helps police gather facts quickly, protects individual rights during questioning, ensures fairness in criminal investigations. Bharatiya Nagarik Suraksha Sanhita 2023 Section 162 Statements to police not to be signed. Use of statements in evidence. What is Section 162 about? Section 162 lays down how statements made to the police during investigation can be used in court and how they cannot be used. It is a key safeguard to ensure fair trials and prevent misuse of police-recorded statements. Main provisions of Section 162. 1 key cap: no signing of police statements. Any statement made to the police during investigation shall not be signed by the person making it. Though limited use in court, such statements cannot be used as evidence in court, except to contradict the witness during trial as per law. 3. Who can use it? The statement may be used by the accused or the prosecution. Only for contradiction, not as substantive proof. 4. Exception for dying declaration. This section does not affect the admissibility of a dying declaration if otherwise lawful. Simple meaning: what a witness tells the police is meant to help investigation, not to become automatic evidence. Courts rely on statements made on oath in court, not on unsigned police notes. Police statements are mainly used to check consistency of a witness's testimony, expose contradictions, if any. Example: a witness tells police one version during investigation. In court, the witness says something different. The earlier police statement can be shown only to point out the contradiction, not to prove the facts directly. Purpose of Section 162: prevents coercion or fabrication of statements, protects witnesses and accused persons, ensures evidence is tested in open court. Bharatiya Nagarik Suraksha Sanhita 2023. Section 163: no inducement, threat or promise to be made. What is Section 163 about? Section 163 strictly prohibits the police from using force, threats, inducement, or promises while recording statements during investigation. It safeguards the free will and dignity of persons being examined. Main provisions of Section 163: no coercion or pressure. No police officer or person in authority shall induce, threaten, or promise anything to a person to make them give a statement, though voluntary statements only. Any statement made during investigation must be voluntary and given without fear or temptation. 3. Key cap protection of accused and witnesses. This protection applies to accused persons and witnesses alike. Simple meaning: police cannot force or manipulate anyone to say something during investigation. They cannot threaten arrest or punishment, promise release, favor, or benefit, use pressure or intimidation. Only free and voluntary statements are acceptable in law. Example: police tell a suspect, "If you confess, we will let you go." Such a statement is illegal under Section 163. Any confession obtained this way has no legal value. Purpose of Section 163 prevents forced confessions, protects human rights and dignity, ensures fairness and reliability in investigations. Bharatiya Nagarik Suraksha Sanhita 2023 Section 164 Recording of confessions and statements by magistrate. What is Section 164 about? Section 164 explains how confessions and statements of witnesses or accused persons are to be recorded by magistrate. It is a crucial safeguard to ensure that confessions are voluntary, lawful, and reliable. Main provisions of Section 164. One key cap who can record the statement. Only a judicial magistrate or metropolitan magistrate can record. Confessions of accused persons and statements of witnesses. Though voluntary confession. Before recording a confession, the magistrate must explain that the person is not bound to confess and warn that the confession may be used against him. The magistrate must be satisfied that the confession is made voluntarily, without pressure. Time for reflection. The accused must be given adequate time to think. Police must not be present during recording. 4 recording method. Confession or statement shall be recorded in writing or electronically. Read over to the person and signed by the maker and the magistrate. 5 refusal to confess. If the accused refuses to confess, the magistrate cannot force him and must record such refusal. Simple meaning. If someone wants to confess or give an important statement, it must be done before a magistrate, not police. The magistrate ensures no force, fear, or promise is involved. This makes the confession legally trustworthy. Example: police arrest a person for a serious offense. The accused says he wants to confess. He is produced before a magistrate. The magistrate explains his rights, gives him time to think, records the confession only if it is voluntary. Purpose of Section 164 prevents forced or fake confessions, protects constitutional rights of accused persons, ensures fairness and credibility in criminal trials. Bharatiya Nagarik Suraksha Sanhita 2023 Section 165 Search by Police Officer. What is Section 165 about? Section 165 empowers a police officer to conduct a search without a warrant during an investigation, but only in urgent situations and subject to strict safeguards. Main provisions of Section 165. One key cap when warrantless search is allowed. A police officer may search without a warrant if he has reasonable grounds to believe that something necessary for investigation is located at a place, and getting a warrant would cause undue delay and defeat the purpose. Though reasons must be recorded. The officer must record in writing the grounds of his belief and the item he is searching for. Teen scope of search. The search must be limited to what is necessary for the investigation. If required, the officer may search any place within his jurisdiction. Calling independent witnesses. The search should be conducted in the presence of independent witnesses as far as possible. 5. Search by subordinate. If the officer in charge cannot conduct the search, he may authorize a subordinate officer in writing to do so. 6. Copy of search record. A copy of the recorded reasons must be sent to the magistrate and given to the occupier of the place searched on request. Simple meaning: police can search a place without prior court permission only when the situation is urgent and delay would harm the investigation. But to prevent misuse, they must write down reasons, follow proper procedure, and remain accountable to the magistrate. Example: police are investigating a robbery. They receive reliable information that stolen goods are hidden in a house. Waiting for a warrant may allow the accused to remove the goods. Under Section 165, police may search immediately, record reasons, and inform the magistrate afterward. Purpose of Section 165: enables quick police action in urgent cases, prevents destruction or removal of evidence, balances investigation needs with individual rights. Bharatiya Nagarik Suraksha Sanhita 2023. Section 166. When officer in charge of police station may require another to issue search warrant. What is Section 166 about? Section 166 deals with situations where a police officer needs to conduct a search outside his own police station's jurisdiction. It explains how inter-district or inter-station searches should be carried out lawfully. Main provisions of Section 166. एक search outside jurisdiction. If a police officer believes that evidence is located outside his police station limits, he cannot directly search that place on his own authority, except in urgent cases under Section 165. Though request to local police, the officer must send a written request to the officer in charge of the police station within whose jurisdiction the place is situated. 3 key cap role of local police officer. The local officer shall apply for a search warrant and conduct the search according to law. 4 urgent situations. If delay would defeat the purpose, the investigating officer may himself conduct the search, but must immediately send notice and reasons to the local police station. Simple meaning: police officers must respect territorial limits. Normally, they must take the help of the local police station to search a place. Only in urgent cases can they act directly. This prevents misuse of power and ensures local supervision. Example: a police officer from District A is investigating a fraud case. Important documents are believed to be in District B. The officer sends a written request to the police station in District B. The local police obtain a warrant and conduct the search. If delay is dangerous, the officer may search immediately but must inform the local police. Purpose of Section 166 respects jurisdictional boundaries, prevents arbitrary police action, ensures coordination between police stations. Bharatiya Nagarik Suraksha Sanhita 2023. Section 167 Procedure when investigation cannot be completed in 24 hours. What is Section 167 about? Section 167 explains what the police must do when an investigation cannot be completed within 24 hours of arrest. It lays down the rules for police custody, judicial custody, and remand by magistrate. Main provisions of Section 167. एक production before magistrate. If investigation cannot be completed within 24 hours, the accused must be produced before a magistrate. The police must forward the case diary and grounds for detention to key cap police custody or judicial custody. The magistrate may authorize police custody or judicial custody for a maximum of 15 days in total. 3. Extended judicial custody. If investigation still continues, the magistrate may authorize further judicial custody, not police custody, up to 90 days for serious offences or 60 days for other offences. 4. Default bail. If the charge sheet is not filed within 60 or 90 days, the accused gets a statutory default right to bail, provided he is ready to furnish bail. 5. Physical or electronic production. The accused may be produced physically or through electronic means, video conferencing, as permitted. Simple meaning: police cannot keep a person in custody indefinitely. After 24 hours, court permission is mandatory. Custody is strictly time-bound. If police delay filing the case, the accused gains a legal right to bail. This section protects personal liberty while allowing fair investigation. Example: a person is arrested for a serious offense. Investigation cannot finish in one day. Police produce him before a magistrate. The magistrate grants 7 days police custody, then judicial custody. If police fail to file the charge sheet within 90 days, the accused can claim default bail. Purpose of Section 167: prevents illegal or prolonged detention. Balances investigation needs with individual liberty. Ensures judicial control over police custody. भारतीय नागरिक सुरक्षा संहिता 2023. Section 168 Report of investigation by subordinate police officer. What is Section 168 about? Section 168 explains what a subordinate police officer must do after completing an investigation assigned to him. It focuses on reporting and supervision within the police hierarchy. Main provisions of Section 168. 1. Submission of report. When a subordinate police officer completes an investigation, he must submit a report of the investigation to the officer in charge of the police station. To keycap no direct reporting to magistrate. The subordinate officer does not send the report directly to the magistrate. The officer in charge examines the report and then takes appropriate action under the law, such as proceeding under the next section. Simple meaning: investigations often involve multiple officers. A junior or subordinate officer may do the field investigation. But he must report to the station house officer, SHO. The SHO is responsible for forwarding the final police report to the court. This ensures proper supervision and accountability. Example: and SHO assigns a constable or sub-inspector to investigate a theft case. After finishing the investigation, the subordinate officer submits his findings to the SHO. The SHO then decides whether to file a charge sheet or close the case as per law. Purpose of Section 168: maintains discipline and hierarchy in police investigations, ensures senior officer oversight, improves accuracy and responsibility in police reports. भारतीय नागरिक सुरक्षा संहिता 2023 Section 169 Release of accused when evidence is deficient. What is Section 169 about? Section 169 deals with the situation where, after investigation, the police find that there is not enough evidence or reasonable suspicion to justify sending the accused for trial. Main provisions of Section 169. 1. Insufficient evidence. If the investigating officer finds no sufficient evidence and no reasonable ground of suspicion against the accused, though release of accused, the accused shall be released without charge and without sending him to court for trial. 3. Key cap bond to appear if required. The police may require the accused to execute a bond with or without sureties, to appear before a magistrate if and when required later. Simple meaning: if the investigation shows that the case is weak or the allegations are not supported by evidence, then the accused should not be unnecessarily prosecuted or detained. He is released, but may be asked to promise to appear later if needed. This protects innocent persons from harassment and unnecessary trials. Example: a person is arrested for cheating. During investigation, police find no documents, no witnesses supporting the allegation. Under Section 169, the accused is released after signing a bond to appear if the court later calls him. Purpose of Section 169: prevents misuse of criminal process, protects personal liberty, ensures only genuine cases go to trial. भारतीय नागरिक सुरक्षा संहिता 2023 Section 170 Case to be sent to magistrate when evidence is sufficient. What is Section 170 about? Section 170 applies when, after investigation, the police finds sufficient evidence or reasonable grounds to proceed against the accused. It explains what the police must do next before the case goes to trial. Main provisions of Section 170. 1. Sufficient evidence found. If the investigating officer believes there is enough evidence or reasonable ground to proceed, to keycap accused to be forwarded to magistrate. The accused shall be sent to the magistrate having jurisdiction or produced before the magistrate if already in custody. 3. Custody or bond. If the offence is bailable and the accused is ready to furnish bail, he shall be released on bail to appear before the magistrate. If not, The accused may be sent in custody. Char documents and witnesses. The police must forward all relevant documents and ensure the attendance of witnesses before the magistrate. Simple meaning: when the police complete investigation and find the case is strong enough, the matter is placed before the court. The court, not the police, decides the future course: trial, bail, or discharge. This marks the transition from investigation to judicial proceedings. Example: police investigate a burglary. They collect CCTV footage, stolen property, and witness statements. Finding sufficient evidence, they produce the accused before the magistrate under Section 170, along with case papers and witnesses. Purpose of Section 170: ensures cases with merit reach the court. Maintains judicial control after investigation. Protects accused rights through bail and court oversight. Bharatiya Nagarik Suraksha Sanhita, 2023. Section 171, complainants and witnesses not to be required to accompany police or to be subjected to restraint. What is Section 171 about? Section 171 protects complainants and witnesses from unnecessary harassment by the police during investigation. It ensures they are not forced to travel with police or kept under restraint except where the law strictly requires. Main provisions of Section 171. 1 key cap: no compulsion to accompany police. A complainant or witness shall not be required to accompany a police officer during investigation. Though no restraint, such persons shall not be subjected to restraint, detention, or confinement unless there is legal justification, for example, lawful arrest under law. Protection of personal liberty. The section reinforces that witnesses and complainants are not accused persons. They must be treated with dignity and freedom. Simple meaning: if you are a witness or complainant, police cannot detain you. Police cannot force you to go along with them unless there is a clear legal reason. Your role is to assist justice, not to suffer inconvenience or pressure. Example: a person reports a crime and gives a statement. Police cannot force him to travel to another city or stay at the police station. He may cooperate voluntarily but cannot be compelled. Purpose of Section 171: prevents misuse of police authority. Protects witnesses from intimidation. Encourages people to come forward and report crimes. Bharatiya Nagarik Suraksha Sanhita, 2023. Section 172, Diary of Proceedings in Investigation, Case Diary. What is Section 172 about? Section 172 requires every investigating police officer to maintain a case diary during investigation. This diary records day-to-day progress of the investigation and helps the court supervise fairness. Main provisions of Section 172. एक maintenance of case diary. The investigating officer must keep a diary showing time when information was received, time when investigation began and ended each day, places visited, and facts discovered. The purpose of the diary. The diary is meant to assist the court in understanding the investigation, check whether the investigation was conducted properly. Theme used by the court. A court may call for and use the diary to aid inquiry or trial. However, the diary itself is not evidence. Char limited access to accused. The accused or his lawyer has no right to inspect the case diary as a matter of course. It may be used only to contradict a police officer if he testifies in court as permitted by law. Simple meaning. Police must document every step they take while investigating a case. This creates transparency and accountability. Courts can verify whether the investigation was genuine, timely, and lawful. But the diary is not a substitute for evidence given in court. Example: during a murder investigation, the officer notes each day which witnesses were examined, which locations were visited, what facts were discovered. If a dispute arises about police conduct, the court may look at the case diary to assess fairness. Purpose of Section 172. Ensures systematic and honest investigation. Enables judicial supervision of police work. Prevents fabrication or afterthoughts in investigation. Bharatiya Nagarik Suraksha Sanhita, 2023. Section 173. Report of Police Officer on completion of investigation, charge sheet final report. What is Section 173 about? Section 173 explains what the police must do after completing the investigation. It deals with the final police report, commonly known as the charge sheet or closure report, which is submitted to the magistrate. Main provisions of Section 173. Submission of final report. After completing investigation, the officer in charge of the police station must submit a report to the magistrate having jurisdiction. The contents of the report. The report includes names of the parties, nature of the information, offense details, names of witnesses, whether an offense appears to have been committed, whether the accused has been arrested or released on bail, whether the accused is in custody. Time-bound investigation. Investigation should be completed without unnecessary delay. Special categories of cases may have prescribed timelines. 4. Further investigation. Even after submitting the report, police may conduct further investigation if new evidence comes up and submit a supplementary report to the magistrate. 5. Documents to accused. Copies of relevant documents and statements must be furnished to the accused as required by law. Simple meaning: once police finish investigating, they must formally inform the court of the result. If evidence is sufficient, charge sheet filed, trial begins. If evidence is insufficient, closure report may be filed. The magistrate then decides whether to take cognizance, order further investigation, or discharge the accused. Example: police investigate a cheating case. After collecting documents and witness statements, they file a charge sheet under Section 173. The magistrate examines the report and takes cognizance and starts court proceedings. Purpose of Section 173 marks the end of police investigation, transfers control of the case to the judiciary, ensures transparency and procedural fairness. Bharatiya Nagarik Suraksha Sanhita 2023. Section 174. Police to inquire and report on suicide, death, etc. Inquest. What is Section 174 about? Section 174 deals with the police procedure when there is a suspicious, unnatural, or unexplained death. It requires the police to conduct an inquest and report the circumstances of death. Main provisions of Section 174. 1. When inquest is required, the police must act when information is received about suicide, death by accident, death by animal attack, death under suspicious circumstances, death in police custody or otherwise unnatural death. Though police inquiry, inquest, the officer in charge shall inform the executive magistrate and proceed to the place where the body is found. He shall conduct an inquest in the presence of 2 or more respectable persons of the locality, 5 witnesses. 3. Inquest report. The officer prepares a written report describing apparent cause of death, any injuries, marks, or signs on the body, circumstances indicating how the death occurred. 4. Post-mortem examination. If there is doubt about the cause of death, the body may be sent for post-mortem examination by a medical officer. 5. Key cap special care in custody deaths. In cases of death in police custody or custody of authorities, mandatory intimation to the magistrate and higher authorities. Simple meaning: when a death looks unnatural or suspicious, police must examine the situation carefully, prepare an official record, inquest report, and take medical opinion if needed. This ensures transparency and accountability, especially in sensitive deaths. Example: a person is found dead in a house under unclear circumstances. Police visit the spot, conduct an inquest with local witnesses, prepare a report, and send the body for post-mortem if required. Purpose of Section 174: ensures proper inquiry into suspicious deaths, prevents concealment of crimes, protects public interest and human rights. भारतीय नागरिक सुरक्षा संहिता 2023 Section 175 Power to summon persons to give evidence and produce documents. What is Section 175 about? Section 175 gives the police the legal power to summon persons during an investigation to give information or evidence and/or produce documents or things relevant to the case. This power supports the inquest and investigation process, especially under Sections 174 and related provisions. Main provisions of Section 175: एक power to summon. A police officer conducting an investigation or inquest may summon any person who appears to be acquainted with the facts of the case or require a person to produce any document or thing necessary for the investigation. Though obligation to comply. A person so summoned is legally bound to attend and bound to answer truly all questions except those that may incriminate him. Teen protection against self-incrimination. No person is required to answer any question that would expose him to a criminal charge or penalty. Char written order. The summons or requirement should ordinarily be in writing, specifying what is required. Simple meaning: police can legally ask people to come and give information or bring documents related to a case. But people cannot be forced to confess guilt. Their constitutional rights remain protected. Example: during investigation of a suspicious death, police summon a doctor to explain medical records or ask a landlord to produce CCTV footage. These persons must cooperate unless answering would incriminate them. Purpose of Section 175: helps police collect evidence lawfully, ensures cooperation of witnesses and custodians of documents, balances investigative power with individual rights. भारतीय नागरिक सुरक्षा संहिता 2023 Section 176 Inquiry by magistrate into cause of death. What is Section 176 about? Section 176 requires a magisterial inquiry into certain types of deaths, especially where the death is suspicious or occurs in custody. It acts as an additional safeguard beyond the police inquest under Section 174. Main provisions of Section 176. एक mandatory magistrate inquiry. A magistrate shall hold an inquiry into the cause of death when the death occurs. In police custody, in judicial custody, or in any other custody authorized by law. Though inquiry in special cases. The magistrate may also conduct an inquiry when a person dies, disappears, or is alleged to have been raped while in custody. 3. Independent judicial oversight. This inquiry is independent of the police investigation. The magistrate examines circumstances of death, possible abuse of power, compliance with legal safeguards, char post-mortem and medical examination. The magistrate may order a post-mortem examination and, in appropriate cases, direct video recording of the post-mortem. 5. Transparency. Relatives of the deceased may be informed and allowed to participate as per law. Simple meaning: when a death happens in custody or under suspicious circumstances, the law does not rely only on police inquiry. Instead, a magistrate independently investigates the cause of death. To ensure fairness, transparency, and accountability. Example: a person dies while in police lockup. Police conduct an inquest under Section 174. Additionally, under Section 176, a magistrate conducts an independent inquiry. Orders post-mortem. Examines whether there was negligence or misconduct. Purpose of Section 176. Protects human rights. Prevents custodial abuse. Ensures judicial accountability in sensitive cases. Bharatiya Nagarik Suraksha Sanhita, 2023. Section 177, Ordinary Place of Inquiry and Trial. What is Section 177 about? Section 177 lays down the general rule about where an offence should be inquired into and tried. It fixes the territorial jurisdiction of criminal courts. Main provision of Section 177. Every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction the offence was committed. This is the basic rule for deciding the proper court. Simple meaning: as a rule, a criminal case should be tried at the place where the crime happened. This ensures convenience of witnesses, availability of evidence, and fairness to both the accused and the victim. Example: a theft is committed in Lucknow. Under Section 177, the case should ordinarily be investigated and tried by a court in Lucknow. not in some other city without legal reason. Purpose of Section 177 establishes a clear and simple rule of jurisdiction, prevents forum shopping or arbitrary choice of courts, promotes fair and efficient trials. भारतीय नागरिक सुरक्षा संहिता 2023 Section 178 Place of inquiry or trial in certain cases. What is Section 178 about? Section 178 provides exceptions to the general rule in Section 177. It explains where an offence may be inquired into or tried when the place of commission is uncertain or spread over multiple areas. Main situations covered by Section 178. An offence may be inquired into or tried by a court having jurisdiction over any of the relevant local areas when एक uncertain place of offence. It is uncertain in which local area the offence was committed. To keycap offence committed partly in different areas. The offence is committed partly in one area and partly in another. Teen continuing offence. The offence is a continuing one, committed in more than one local area over time. 4 keycap multiple acts in different areas. The offence consists of several acts, each done in different local areas. Simple meaning: when a crime has no single clear location or spreads across multiple places, then any one of those places courts can try the case. This avoids confusion and ensures the case is not blocked due to jurisdictional technicalities. Examples: cyber fraud committed online from City A affecting a victim in City B courts in either city may have jurisdiction. Kidnapping where abduction happens in District X and confinement in District Y courts in X or Y can try the case. Continuing offence like illegal construction ongoing in multiple areas courts in any affected area can take the case. Purpose of Section 178 provides flexibility in complex cases, prevents offenders from escaping due to jurisdiction issues, ensures effective and practical administration of justice. भारतीय नागरिक सुरक्षा संहिता 2023 Section 179 Offence triable where act is done or consequence ensues. What is Section 179 about? Section 179 deals with offences where the act is done in one place, but the result or consequence occurs in another place. It clarifies which court has jurisdiction in such situations. Main provision of Section 179. When an act is done in one local area and the consequence of that act occurs in another local area, the offence may be inquired into, or tried by a court having jurisdiction over either area. Simple meaning: if a crime starts in one place and causes harm or effect in another place, then courts of both places are competent to try the case. Examples: cheating, false representation made in City A, money delivered in City B, courts in A or B can try the case. Defamation, statement published in City X, reputation harmed in City Y, courts in X or Y have jurisdiction. Cybercrime, email sent from one city, victim suffers loss in another jurisdiction in both places. Purpose of Section 179 covers offences with cross-border effects, prevents jurisdictional confusion, ensures victims can seek justice where harm is felt. भारतीय नागरिक सुरक्षा संहिता 2023 Section 180 Place of trial where act is an offence by reason of relation to other offence. What is Section 180 about? Section 180 applies when an act becomes an offence because of its connection with another offence. It explains which court has jurisdiction in such linked or dependent offences. Main provision of Section 180. When an act is an offence by reason of its relation to another offence, the case may be inquired into or tried by a court having jurisdiction over the place where the first offence was committed or the place where the connected offence was committed. Simple meaning: some acts are crimes only because they are connected to another crime. In such cases, the trial can take place where either offence occurred. This avoids splitting connected matters across different courts. Examples: abetment. Abetment done in City A, main offence committed in City B, courts in A or B can try the case. Receiving stolen property. Theft occurs in District X. Stolen property received in District Y, courts in X or Y have jurisdiction. Harboring an offender. Harboring in one place, offence committed elsewhere, jurisdiction in either place. Purpose of Section 180 ensures effective trial of connected offences, prevents fragmentation of cases, promotes judicial convenience and consistency. भारतीय नागरिक सुरक्षा संहिता 2023 Section 181 Place of trial in certain special offences. What is Section 181 about? Section 181 specifies special rules for deciding the place of inquiry or trial for certain categories of offences. These are exceptions to the general jurisdiction rules in Sections 177, 180. Offences covered under Section 181. The following offences may be inquired into or tried at specific places as stated below. 1 keycap thug, dacoity, or murder in dacoity. Trial may be held where the offence was committed or The accused is found. Though kidnapping or abduction. Trial may be held where the person was kidnapped, abducted, or the person was conveyed, concealed, or detained, or the accused is found. Teen theft, robbery, dacoity. Trial may be held where the offense was committed or the stolen property was possessed, received, or retained. 4 key cap criminal misappropriation or criminal breach of trust. Trial may be held where the offense was committed or the property was received or retained, or the accused was required to account for the property. Simple meaning. For some offences, multiple places are legally acceptable for trial. This helps because such crimes often involve movement of persons or property, and limiting trial to only one place would cause difficulty or injustice. Examples: kidnapping. Victim kidnapped in City A, kept in City B courts in A, or B can try the case. Theft. Theft in District X. Stolen goods found in District Y courts in X or Y have jurisdiction. Criminal breach of trust. Money entrusted in one city, misused in another trial in either place. Purpose of Section 181 makes trials practical and effective. Prevents offenders from avoiding prosecution by moving locations. Supports speedy and convenient justice. Bharatiya Nagarik Suraksha Sanhita, 2023. Section 182 Offences committed by letters, electronic communications, etc. What is Section 182 about? Section 182 explains where an offence can be tried when it is committed through letters, messages, emails, or electronic communications. It is especially important for cyber and communication-based offences. Main provision of Section 182. When an offence is committed by means of letters, messages, emails, electronic or digital communication, the offence may be inquired into or tried by a court having jurisdiction over the place where the communication was sent or the place where the communication was received. Simple meaning. If a crime is committed using communication tools, the case can be tried where the message originated or where its effect was felt, received. This prevents offenders from escaping liability by operating from distant locations. Examples: threatening email sent from City A to a person in City B courts in A, or B can try the case. Online cheating where messages are sent from one state and money is received in another jurisdiction in both places. Defamation through social media trial where post was uploaded or where it was read. Purpose of Section 182 addresses modern digital and communication-based crimes. Removes jurisdictional hurdles in cyber offences. Ensures effective legal remedy for victims. Bharatiya Nagarik Suraksha Sanhita, 2023. Section 183. Offence committed on a journey or voyage. What is Section 183 about? Section 183 explains where an offence can be inquired into or tried when it is committed during a journey or voyage. This includes offences committed while travelling by road, rail, sea, or air. Main provision of Section 183. When an offence is committed during a journey or during a voyage by ship, boat, aircraft, etc. The offence may be inquired into or tried by a court having jurisdiction over the place from where the journey or voyage began, or the place where the journey or voyage ended. Simple meaning: if a crime happens while traveling, the law does not require identifying the exact point where the offence occurred. The case can be tried either at the starting point or at the ending point of the journey. This avoids confusion and delay in deciding jurisdiction. Examples: a theft occurs on a train traveling from city A to city B. Courts in A or B can try the case. An offence is committed on a flight from Delhi to Mumbai. Jurisdiction lies in Delhi or Mumbai. A crime happens on a ship sailing from one port to another. Trial at either port. Purpose of Section 183. Simplifies jurisdiction for offences committed in transit. Prevents technical objections about exact location. Ensures speedy and effective prosecution. Bharatiya Nagarik Suraksha Sanhita, 2023. Section 184. Place of trial for offences triable together. What is Section 184 about? Section 184 explains where a trial should be held when multiple offences are committed by the same person and those offences can be tried together. It helps decide the proper court to avoid multiple trials in different places. Main provision of Section 184. When a person has committed several offences and those offences may be tried together under the law. The offences may be inquired into or tried by any court having jurisdiction over any one of those offences. Simple meaning: if one person commits multiple related crimes in different places, the law allows one court to try all of them together, instead of forcing separate trials in different locations. This saves time, cost, and judicial effort. Examples: a person commits cheating in city A and forgery in city B as part of the same transaction. A court in city A or city B can try both offences together. A criminal commits a series of thefts in nearby districts as part of one scheme. Any court with jurisdiction over one theft may try all the cases together. Purpose of Section 184. Prevents multiple and fragmented trials. Ensures efficient and speedy justice. Reduces inconvenience to courts, witnesses, and parties. Bharatiya Nagarik Suraksha Sanhita 2023